White collar crime. White collar crime. White collar crime. White collar crime. YouTube channel Research and Criminology. YouTube channel Research and Criminology. YouTube channel Research and Criminology. Facebook page Research and Criminology. Facebook page Research and Criminology. Please like, subscribe and comments. Thank you. Corporate crime. Corporate crime. 7. Corporate crime. The final component of white collar crime involves situations in which powerful institutions or their representatives willfully violate the laws that restrain these institutions from doing social harm or require them to do social good. This is also known as corporate or organizational crime. Corporate crime is probably what Sutherland had most in mind when he coined the term white collar crime. These illegal acts are committed by the wealthy and powerful to further their business interests. They include such acts as price fixing and illegal restraint of trade, false advertising, and the use of company practices that violate environmental protection statutes. The variety of crimes contained within this category is great, and the damage they cause vast. The following subsections will examine some of the most important offences individually. 7A. Illegal restraint of trade and price fixing. Illegal restraint of trade and price fixing. A restraint of trade involves a contract or conspiracy designed to stifle competition, create a monopoly, artificially maintain prices, or otherwise interfere with free market competition. The control of restraint of trade violations has its legal basis in the Sherman Anti-Trust Act. For violation of its provisions, this federal law created criminal penalties of up to 3 years imprisonment and $1 lakh in fines for individuals and $1 million in fines for corporations. The Sherman Antitrust Act outlaws conspiracies between corporations designed to control the marketplace. In most instances, the Act leaves to the presiding court's judgment the determination of whether corporations have conspired to unreasonably restrain competition. However, Four types of market conditions are considered so inherently anti-competitive that federal courts through the Sherman Anti-Trust Act have defined them as illegal per se, without regard to the facts or circumstances of the case. The first is division of markets. Here, firms divide a region into territories, and each firm agrees not to compete in the other's territories. The second is the type arrangement in which a corporation requires customers of one of its services to use other services it offers. For example, in the case of Northern Pacific Railway Corporation versus United States, a federal court ruled that the railroad's requirement that all tenants of its land use the railroad to ship all goods produced on the land was an illegal restraint of trade. A third type of absolute Sherman Act violation is group boycotts, in which an organization or company boycotts retail stores that do not comply with its rules or desires. Finally, price fixing, a conspiracy to set and control the price of a necessary commodity, is considered an absolute violation of the Act. Of all the criminal violations associated with restraint of trade, none perhaps is as important as price fixing. Michael Maltz and Stephen Pollack have described the four forms this act usually takes. The first is predation, in which large firms agree among themselves to bid below market prices to drive out weaker firms. The goal is to reduce competition and permit the remaining firms to raise their prices with relative impunity. A second scheme is identical bidding. Here, all competitors agree to submit identical bids for each contract, although they may vary bids from contract to contract. The price is well above what would have been expected if collusion had not occurred. Purchasing agents use their discretion to choose among bidders. However, identical bidding usually assures all vendors of getting a share of the market without losing any profitability. Geographical market sharing. Geographical market sharing involves dividing the potential market into territories within which only one member of the conspiring group is permitted a low bid. The remaining conspirators either refrain from bidding or give artificially high bids. Rotational bidding involves a conspiracy in which the opportunity to submit a winning bid for a government or business contract is rotated among the institutional bidders. The conspirators meet in advance and determine who will give the low bid. The winning bid is, of course, higher than it should be, since the losers have all submitted abnormally high bids. Close coordination among the bidders is essential. Therefore, these schemes usually involve only a few large firms. Despite enforcement efforts, restraint of trade conspiracies are quite common. The best known case involved some of the largest members of the electrical equipment industry. In 1961, 21 corporations, including industry leaders, Westinghouse, and General Electric, were successfully prosecuted. 45 executives were found guilty of criminal violations of the Sherman Anti-Trust Act. Company executives met secretly. They referred to their meetings as choir practice and arrange the setting of prices on sales of equipment, the allocation of markets and territories, and the rigging of bids. At the sentencing, fines amounting to 19,24,500 were levied against the defendants, including $4,37,500 against General Electric and $3,72,500 against Washington House. Although these fines meant little to the giant corporations, subsequent civil suits cost General Electric $160 million fine. $160 million. Even more significant was that 7 defendants, all high-ranking executives, were sentenced to jail terms. Not all price fixing is done by billion-dollar corporations. In 1990, a federal grand jury indicted the Manchester company for allegedly conspiring with its competitors, the Strite Company and Horowitz Margareten Company, in order to fix the price of Medzos, the unleavened bread eaten by religious Jews during the Passover holiday. 7b. Deceptive pricing. It is common for even the largest US corporations to use deceptive pricing schemes when they respond to contract solicitations. Deceptive pricing occurs when contractors provide the government or other corporation with incomplete or misleading information on how much it will actually cost to fulfill the contract they are bidding on, or use mischarging once the contracts are signed. For example, defense contractors have been prosecuted for charging the government for costs actually incurred on work they are doing for private firms or shifting the cost on fixed price contracts to ones in which the government reimburses the contractor for all expenses, cost plus contracts. One well-known example of deceptive pricing occurred when the Lockheed Corporation withheld information that its wage cost would be lower than expected on the C-5 cargo plane. The resulting overcharges were an estimated $10 million. Though the government was able to negotiate a cheaper price for future C-5 orders, it did not demand repayment on the earlier contract. The government prosecutes approximately 100 cases of deceptive pricing in defense work each year, involving 59% of the nation's largest contractors. 7c. False claims and advertising. In 1991, the Food and Drug Administration seized all the Citrus Hill orange juice stored in a Minneapolis warehouse. It seems that the nation's third largest selling breakfast drink had billed itself as pure squeezed, 100% pure and fresh, despite the fact that it was made from concentrate. The federal agency also objected to the fact that Procter & Gamble, which sells Citrus Hill, claimed we pick our oranges at the peak of ripeness. then we hurry to squeeze them before they lose their freshness. Executives in even the largest corporations are sometimes caught in the position in which stockholders' expectations of ever increasing company profits seem to demand that sales be increased at any cost. At times, executives respond to this challenge by making claims about the product that cannot be justified by its actual performance. However, the line between clever, aggressive sales techniques and fraudulent claims is a fine one. It is traditional to show a product in its best light, even if that involves restoring to fantasy. Thus, we cannot really say it is fraudulent to show a crown suddenly appearing on the head of a person eating a certain brand of margarine, nor is it fraudulent to imply that taking one sip of iced tea will make people feel they have just jumped into a swimming pool. However, it is illegal to knowingly and purposely advertise a product as possessing qualities that the manufacturer has realized it does not have. Charges stemming from false and misleading claims have been common in several US industries. For example, the Federal Trade Commission reviewed and disallowed advertising by the three major US car companies that alleged that new cars got higher gas mileage than buyers actually could expect. The Warner Lambert Drug Company was prohibited from claiming that Listerine mouthwash could prevent or cure colds. Sterling Drugs was prohibited from claiming that Lysol disinfectant killed germs associated with colds and flu. The A&P Food Company was sanctioned for mispricing and for advertising unavailable products. An administrative judge ruled that the American Home Products Company falsely advertised Anacin as a tension reliever. The list seems to go on endlessly. In the pharmaceutical industry, false advertising has a long history. It has been common for medicines to be advertised as cure-alls for previously incurable diseases. Such medicines include alleged cures for cancer and arthritis, and drug advertised to give energy and sexual potency. How can we explain the frequency of false advertising by drug manufacturers? Often the problem arises because several competing companies market similar products, and the key to successful sales is believed to be convincing the public that one of these products is far superior to the rest. Sometimes the intense drive for profits leads to falsification of data and unethical and illegal sales promotions. For example, when the Richardson Merrill Pharmaceutical Company launched a highly aggressive campaign for an anti-cholesterol drug, Merck 29, it downplayed efforts to warn the public about the drug's harmful side effects, such as sexual dysfunction, loss of hair, and development of eye cataracts. Even after the company learned of these problems, it issued a memorandum to its salespeople warning them to avoid mentioning the problems. When warnings were finally issued, their purpose was to protect the company against damage suits rather than to aid customers. Eventually, permission to market the drug was withdrawn by the Food and Drug Administration, though no criminal charges were filed. One commentator has stated, "Here we see a company in a highly competitive and highly profitable industry resorting to unethical and probably illegal tactics to sell its products." The Merrill-Richardson case is certainly not the end of such matters. In 1984, the SmithKline-Bachmann Corporation pleaded guilty to failing to make timely reports on a drug Salacrine, which was linked to 25 deaths before being removed from the market. Despite the legal action in US courts, the drug continues to be sold in France. It has been difficult for authorities to police such violations of the public trust. Often the most serious consequences to the corporation is an order that it refrain from using the advertising or withdrawn the advertising claims. Criminal penalties for false claims are rarely given. Recently, 900 telephone numbers have been used to advertise products involving sex and companionship and then charge high fees for each phone call. The Federal Trade Commission has filed charges against some companies that use these numbers for using deception in their ad campaigns by promising services they cannot deliver or overcharging for information calls. 7D. Environmental crimes. Much attention has been paid to the intentional or negligent environmental pollution caused by many large corporations. The numbers allegations in this area involve there are many different types of environmental crimes. Some corporations have endangered the lives of their own workers by maintaining unsafe conditions in their plants and mines. It has been estimated that 21 million workers have been exposed to hazardous materials while on the job. The National Institute of Occupational Safety and Health estimated that it would cost about $40 million just to alert these workers to the danger of their exposure to hazardous waste, and $54 billion to watch them and keep track of whether they developed occupationally related diseases. Some industries have been particularly hard hit by complaints and allegations. The asbestos industry was the target of a flood of lawsuits after environmental scientists found a close association between exposure to asbestos and development of cancer. Over 250,000 people have filed 12,000 lawsuits against 260 asbestos manufacturers. In all, some insurance companies officially estimate asbestos related lawsuits could amount to $120 billion to $150 billion. Similarly, some 1 lakh cotton mill workers suffer from some form of respiratory disease linked to prolonged exposure to cotton dust. About 1/3 of the workers are seriously disabled by brown lung disease, an illness similar to is emphysema. The control of worker safety has been the province of the Occupational Safety and Health Administration (OSHA). OSHA sets industry standards for the proper use of such chemicals as benzene, arsenic, lead, and coke. Intentional violations of OSHA standards can eventually involve criminal penalties. 7E. Environmental pollution. A second type of environmental crime committed by large corporations is the illegal pollution of the environment. Sometimes pollution involves individual acts caused by negligence on the part of the polluter. Two cases stand out. The first involved the leaking of methyl isocyanate from a Union Carbide plant in Bhopal, India on December 3, 1984. Estimates of the death toll range from 1,400 to 10,000 people. Another 60,000 were injured. Union Carbide later reported that the plant had not been operating safely and should have been closed. The firm blamed the negligence, however, and on local officials who were running the plant. The second case occurred when the tanker Exxon Valdez ran aground on a reef off the coast of Alaska on March 24, 1989, dumping 11 million gallons of crude oil and fouling 700 miles of shoreline. On March 13, 1991, Exxon agreed to pay $1 billion in criminal and civil fines rather than face trial. This is the largest amount paid as a result of environmental pollution to date. A federal judge later refused to accept this amount, and the case is still being settled. Equally serious is the prolonged intentional pollution of the environment. A case in point in the illegal dumping of polychlorinated biphenyl (PCB). This compound has been used in 1929 in power transformers, electric typewriters, and electrical capacitors. However, scientists have recently linked PCB to cancer and birth defects in laboratory animals. In Japan, people who ate rice oil contaminated with PCB suffered a variety of health problems. Chemical companies have been ordered not to use PCB. However, disposing of the chemical presents a serious problem. The Environment Protection Agency estimates that 20 million pounds await disposal and that 750 million pounds must eventually be destroyed. Some chemical companies have dumped their PCB stocks along public highways and in remote, illegal dump sites. In some areas, illegal dumped PCB has proven extremely hazardous when it has been carelessly dropped in landfills, pits, and lagoons. PCB has contaminated water, fish, and wildlife. Because of PCB contamination, fishing has been restricted in rivers in New York, Connecticut, Michigan, and other states. The EPA has estimated that the cost of cleaning up the 1,500 to 2,500 hazardous waste dump sites scattered around the United States range from $7.6 billion to $22.7 billion. Their best overall estimate is $11.7 billion. Although the cleanup is expected to be supported by taxes on petrochemicals that go into a super fund, some experts believe that it is unrealistic to believe that private industry will pay for even half the cost. 7F. Controlling environmental pollution. The nature and scope of environmental crimes have promoted the federal government to pass a series of control measures designed to outlaw the worst abuses. These measures are described below. Clean Air Act (CAA). The CAA provides sanctions for companies that do not comply with the air quality standards established by the EPA. The CAA can impose penalties on any person or institution that, for example, knowingly violates EPA plan requirements or emission standards, tamper with EPA monitoring devices, or makes false statements to EPA officials. The Clean Air Act was amended in 1990 to toughen up standards for emissions of many air pollutants. Clean Water Act (CWA). The CWA punishes the knowing or negligent discharge of the pollutant into navigable waters. According to the CWA, the pollutant is any man-made or man-induced alteration of the chemical, physical, biological, and radiological integrity of the water. Rivers and Harbours Act of 1899 Refuse Act. The Refuse Act punishes any discharge of waste materials that damages natural water quality. Resource Conservation and Recovery Act of 1976 RCRA. The RCRA provides criminal penalties for 4 acts involving the illegal treatment of solid waste. Number 1. The knowing transportation of any hazardous waste to a facility that does not have a legal permit for solid waste disposal. Number 2. The knowing treatment, storage, or disposal of any hazardous waste without a government permit or in violation of the provisions of the permit. Number 3. The deliberate making of any false statement or representation in a report filed in compliance with the RCRA. And number 4. The destruction or alteration of record required to be maintained by the RCRA. Toxic Substances Control Act at TSCA. Toxic Substance Control Act TSCA. The TSCA prohibits the following: manufacturing, processing, or distributing chemical mixtures or substances in a manner not in accordance with established testing or manufacturing requirements. Commercial use of a chemical substance or mixture that the commercial user knew was manufactured, processed, or distributed in violation of the TRSCA requirements and non-compliance with the reporting and inspection requirements of the TSCA. Considering the uncertainties of federal budget allocations, there is some question whether these acts can be enforced well enough to effectively deter environmental crimes. Thank you.